Listed motion. Secondary, high secondary. Which year? April monthly list. Motion, high secondary. Motion, high secondary. Content from my order. My order. Order passed by this court. February 16th. Content. Yes. I have directed compensation to be paid. Yes. Yes. 5 lakh to be paid by the respondent number 10, 5 lakh to be paid by the council. Within 2 months.
Council order, council the present chairman does not have already.
I've not observed anything against the present chairman, but council, according to me, cannot avoid the primary responsibility. I'm reading out that portion. In view of the foregoing discussions and reasons, and applying the principles of law discussed above, the following directions are made. Both the respondent number 8 and 10 shall pay rupees 5 lakhs each, as and by way of compensation, to compensate the petitioners for the period between 2015 to September 2021. Both the respondent number 8 and 10 shall pay and deposit a sum of rupees 5 lakh each within 2 months from today in favor of the learned Registrar General of this court. Within 2 months from today. Upon receiving the said total sum of rupees 10 lakhs from both the respondent number 8 and 10, the learned Registrar General shall invest the same in an interest-bearing fixed deposit account with any nationalized bank of his/her choice forthwith. Both the petitioners shall affirm their respective affidavits disclosing their identity documents and submit the same before the learned Registrar General within the time frame to be fixed by the learned Registrar General. The learned advocate on record for the petitioners shall also accompany the petitioners before the learned Registrar General and confirm their identity. The learned Registrar General, at his/her wisdom, after being satisfied with the identity of the petitioners, shall disburse the sum in equal proportion, that is 5 lakhs each with accrued interest thereupon, in favor of the petitioners by crediting their respective salary accounts, after receiving the particulars of the salary account from the petitioners at the earliest. Then, the order of injunction dated August 16, 2023 passed by this court, restraining the respondent number 10 from dealing with his fixed assets, shall automatically stand vacated without any reference to this court immediately upon deposit of the said sum of rupees 5 lakhs by the respondent number 10 with the registrar. Read this.
respect of the CPI council. It's appearance for the.
Petitioner.
No, no, no. We both the state. They are one of the. Mr. Vinod Bhattacharya, audit name has been appearing for the council for West Bengal Board of Family Education.
You write down who is for whom. I'm correcting here and now.
I can make available fresh.
No, no, do it here and now. It was given wrongly then by you at the line. Yes, kindly see. Order that an earlier order to be file.
Everything is like correct. No, for the kind for a decision is what the appearance. The here one
देखिए जजमेंट का देखिए after Asun. After the judgment has been pronounced in open court, the learned counsel appearing for the parties today have pointed out that there are some mistakes in noting down the names of the learned counsel representing the parties. However, they have confirmed that the appearance recorded in the order dated October 6, 2023 are correct. Paragraph. Accordingly, the appearance of the learned counsel for the respective parties are corrected as below. একদম আপনি একটু দায়িত্ব নিয়ে এটা করে দেবেন তো এই অর্ডারের ডেট থেকে ঠিক যেমন যেমন আছে সেইভাবে প্রস্তাব paragraph. This correction shall be incorporated in the judgment pronounced today on February 6, 2024.
This correction shall be incorporated in the judgment pronounced today on February 6, 2020.
Paragraph. 7. Except the corrections as indicated above, the rest of the judgment pronounced today, dated February 6, 2024, stands as it is and without any modification and alteration. Yeah. Yes. Today, the writ petition appears under the heading to be mentioned, the instance of the court. Paragraph. The writ petition number in the order dated December 12, 2023 shall be read and corrected as code WPA 25897 of 2012 in place and instead of WPA 25897 of 2015. Paragraph. The rest of the order dated December 12, 2023 remains unaltered and without any modification. The above correction shall be incorporated in the order dated 12 December 2023. The previous order speaks for itself. Paragraph. Today, the writ petition appears under the heading for dismissal. Paragraph. None appears for the parties nor any accommodation has been sought for. Paragraph. In view of the above, this writ petition number bold code WPA 13 of 2009 stands dismissed for default. Paragraph. Interim order, comma, if any, comma, stands vacated. Same. এটাকে একটু ঘুরিয়ে দেন কম্পিউটার থেকে অনেকটা একটা আমার ব্যাস থ্যাংক ইউ সেম অর্ডার same 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 এই ওনাস হয়ে গেলে না এটা পাঠিয়ে দেবে সার্ভার Same. 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 শুধু এটা হ্যাঁ ঠিকই থাকে next same 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 পাঠিয়ে দিয়ে বলা হবে সার্ভার same
Private.
none appears for the petition and have any accommodation so বাকিটা আগতে একই থাকবে paragraph Mr. Shamim Bari and counsel appears for the private dispute dismissed dismissed same same on the prayer of Mr. Manirul Jamal. On the prayer of Mr. Manirul Jamal and advocate appealing for the petitioner, the writ petition shall appear under the heading hearing second week in the monthly list of May 2024. Paragraph none appears for the respondents. Paragraph we notice affidavit of service. কত ছিল same 30 on the prayer of Mr. Alright. Mr. Shondip Shutrodhar, learned advocate appealing for the petitioner submits that this writ petition has become infructuous and no cause survives, no cause survives any further therein. Paragraph none appears for the respondents. Paragraph in view of the above, this writ petition, কত নম্বর এটা? WPA board 24058 of 2016 stands dismissed as infructuous. Paragraph. Interim order, comma, if any, comma, stands vacant. Next. Dismissed, none appears. None appears. None appears. None appears.
This is a matter that if the coordinate bench is already passed or already issue like the person finally considers.
All right. On the prayer of Mr. Orko Nundi, learned advocate appearing for the petitioner. This writ petition shall appear. All right, here, otherwise I will. The matter shall appear under the heading hearing secondary in the monthly list of May 2024. Paragraph 9 appears for the respondents. Properly put, learned counsel for the petitioner referring to an order dated September 16, 2021, passed by a court bench in WPA 14274 of 2021.
And counsel of petitioner referring to an order dated September 16, 2021, passed by coordinate bench in WPA 14274 of 2021.
Submits that nothing further survives in this writ petition, and the writ petition can be disposed of in that line. In the same line. So dismissed. It was this. Nothing survives in this writ petition. Paragraph. In view of the above, this writ petition shall appear under the heading for orders on March 5, 2020. Paragraph. None appears for the respondent. The petitioner shall serve notice upon the respondents. Yes. Next. Next. 35. None appears for the parties. None appears 35, madam. I'm 35 now. 35 dismissed. Next. 36. On the prayer of MS Shurmishta China, learned advocate appearing for the petitioner, the writ petition shall appear under the heading hearing second reading in the monthly list of May 2024. Paragraph. None appears for the respondents. Paragraph. We notice. Next. None appears. Dismissed. Next. None appears. Dismissed. On the prayer of Mr. Ajay Cholbe, learned advocate appearing for the petitioner, the writ petition shall appear in the monthly list under the heading hearing second read in the monthly list of May 2024. এটা 39 গেল তাই তো আচ্ছা মিস্টার সব্যসাচী মন্ডল learned state advocate led by Mr. Supriyo Chattopadhyay, learned additional government pleader appears for the state. Next. Dismissed. None appears. Dismissed. 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 Dismissal order for 50. So, none appears for the petitioner nor any account short for Mr. Bhaskar. Where is he? Mr. Bhaskar Prasad Bosho, land and additional government petition appears for the state. The review of the above, the petitioner is dismissed for default. Out of 47, only 3 survive. Sorry. Application for 51. Application for देखिए हमें ये भी जाना है. What is the application? Fast over for the day. Fast over for the day. Yes. 52. None appears for the parties, not any accommodation has been sought for. Paragraph. The application shall appear under the heading application for this bracketed for dismissal on February 30, 2024.
Date, under reading for others. Item number 53.
So continuing matter. No more on facts, only on law. You don't know how excellent she has argued. How excellent she has argued. Result is different. Whatever will happen, will happen. But the way she argued, brilliant. One second. Let's see the DI decision, page 45 once. Yes, 45. Place it from the beginning.
In pursuant to the sovereign order against each state county, or by non-justice because of the United order.
Page 44.
The petitioner offered his candidature for being recruited as a duty staff in the school in questions. He has learned that candidates that were recruited by the Indian school incidentally has been forwarded but no question has been having heard that looking for the parties whose own minds know that the same stands before the direction of the system to convey the decision on the panel, the accordance to the managing committee, as well as the position from the teacher of the copy of the change order. Change the prior permission on 7/5/2003. Effective school service commission and not be constituted as a bar for that to be the palace. That question is already done. Question to the solvent order indicates 8/2003 far by from the because of the application. The matter was settled for 2006. But due to the absence of administration of the one meter and the foundations for the he was taken on the non regarding the approval of annual after polling tax account, the district inspector is out in the formula. I will label number 7/5/2008 prior permission for institutions of staff. As per the description by the application. In a meeting which is 17/2008, meeting number 52, the message of the draft only to say that function in by your yes, just for what I think initially it was restricted in the
Publication.
what is the creation? The managing committee findings regulation in the 2008 resolved to the classic on the 6th not to raise the interview of 2008 to order to be further.
Where? What will check? Which portion?
Point number 4 and
Yes. On 6/9.
on 6/9/2008, the managing committee resolved not to raise the interview of 2008 used to order the further resolved to raise the interview on 24/9/2008 to be publicly in the daily newspaper. Once again on 30/9/2008, the managing committee resolved not to raise the interview on 22/9/2008. On 29/2008, accordingly to the newspaper published in the interview on 24/9/2008. On 41/2009, another notice published to hold the interview on 2009, and that has made for the education 7/1/2009. The managing committee approved the plan on 3/2/2009, submitted the papers to the office of the district inspector school out on 6/2/2009. Just calling by the plan is a part of the education where I talked the plan. And it was prepared by this newly constituted thinking. Observation. The school authority of the interview process after receiving the order to the 2008 passed by the honorable escape to the concerned in the matter of which Abdullah with the direction not to hold the accused only sponsored by the people against him. They are liberty to make substitution after taking one publication. These are complicated ways if the picture applied for the post having issued his qualification, then he will also be allowed to appear for the case. The petitioner submitting the copy of the which is issued by the headmaster of 190,008, whereas in another copy, it was clear that someone of the school received the application of 1590,008. And it is also fact that the school of the department published the advertisement on 990,008. The headmaster of the school cannot clarify it. Although there are total 144 numbers of candidates in the state, but only 24 candidates were present on the date of interview. The reason behind it is that the university can only show a few numbers of posters by which they inform the candidates about the date of interview on 1/2009. That means they not inform all the candidates who registered post within the essential condition of interview as published on 26/12/2005. The content of the detailed value of details about working the selection committee was not day of the CPO for the selection, neither the main selection and the main committee chaired after that the selection for everyone under such circumstances the candidate not prepared as per the answer cannot be asked to all the results. Because the distance is every success value and the religion in loss, the medical committee also in forward they also carry this and that's the way is part of it. That both the matters were hard together. It was continued for some time. Changes are participated, then both the matters came up to one. Then due to non-discrimination, we got another matter that is dismissed. Annual candidate were being elected without on the top the pendant, and my right is definitely.
Show me the right you have accrued.
Yes.
An impaneled candidate merely being impaneled as a right.
Yes. That's good. That is the question which might not put forward on the application and might not wanted to hear it on 90. I feel referring something like this.
Two things. First is that. Second is, if after causing the necessary fact-finding inquiry, the DI came to a conclusion that there was an irregularity in the process, he has rightly cancelled it.
That is the question of scrutiny. If I can show, I have played every point of the DI.
All right, that's the second aspect. First,
I have played every aspect of the matter.
No, how your right accrues.
Because I am the candidate.
But if the school does not require any further teacher,
that is not the case now.
That
is I being a candidate, also just
the employer. It is the right of the employer. Employer may say, I have a requirement.
Not employer initially changed the parent and fascinated as I know, in the vacancy lies ahead.
But they don't want to. They don't want to.
Not their option. I acquired a right to the post.
Show me that you have acquired a right.
Yes, Lordship kindly do want as a rule kindly. So just it is a rule given. There might not only one.
Give me a copy.
Yes.
What rule? What is this rule?
Based on rules that include prosecution.
What is the rule called?
The West Bengal students recruitment of non-teaching staff groups.
Right. Not teaching staff rule. Yes. Yes. One second. Rule. This is rule. You are relying upon rule 12. Rule 12.
But here we don't have enough training.
One second. Don't rush. Yes, read it, read it.
On the score that interpretation of this.
No, read it. How this will be apply in this case.
That's what it was.
Read it, sir. Precisely, my question was that. Had there been a school authority? Yes. Why is your right?
Yes, my right.
So this has got no relevance.
Why I prefer that's to go into the merit of the decision.
No. First thing,
No. This school is relevant. That's why I have given a copy.
you show me that the school has challenged.
Who has challenged? I don't know.
Repetition. Where is the fate?
I did a daily replacement and both the matters were hard to get.
Doesn't matter. Where is your right?
Lordship,
Had this been the school's case, I could have understood.
that means, Lord, what I wanted to know, a candidate who participates in a selection process ultimately got selected by going through merit list. If he has been illegally denied appointment, he cannot come. If that be the legal position, I am not accepting the proposal because I am a candidate.
Show me that empaneled candidate in this type of fact situation has a right.
I am giving certain is
If-
and here this is reported in the post created.
1 second, sir. Right of an empaneled candidate.
Yes. 2010.
1 second, sir. 1 second, sir. Right of an 2000.
10, volume 4, PHN Cal,
Yes.
page 69.
Supreme Court. Okay.
No, that is the-
That's right. CHN. No, you said Cal. That's why I said it has to be Cal. CHN page.
69.
Normally, when those Supreme Court decisions are mentioned, right? Okay. Paragraph.
No, no,
We need Phiruddin.
Type of panel.
Lifetime of pen.
Right type of panel. Continuous panel. Right of appointment against the post selected candidate cannot be taken away on the pretext that candidate has already expired and post has already been filled up by someone. Obstruction of post due to erroneous decision on the part of the appointing authority and not on the part of the selected candidate. You see?
How will it help you, sir?
Because here's a candidate, I am a participant.
They have not denied that the panel has been expired. They have denied that the entire selection process was illegal.
That should be the subject of scrutiny. If I
Who shall
should show,
scrutinize? Who shall scrutinize? Correct. Who will scrutinize?
Honorable Court will scrutinize.
At whose instance?
At my surface,
Why?
I acquired.
That show me that
I acquired the rights in the post.
show me that judgment. This judgment will not help you. Very well, you place it. Whatever judgment you want to place, you place it. Paragraph.
Paragraph, not first in this court, they have referred one judgment of Honorable Supreme Court, Lord, that is page 73.
Yes.
Paragraph 60.
16.
Paragraph 16, Lord, in case of Purushottam Bhaskar chairman, reporting in certain Honorable Supreme Court of South, and that referred to paragraph against 14. The right of the applicant to be appointed against the post to which he has been selected cannot be taken away on the pretext that the state panel has been the meter expired and the post has not been filled up by someone else. A selection of the state post by somebody else is not on the part of the applicant. But on erroneous teaching of the imperative who that you the matter that is right to be appointed the food has been illegally taken away by the implement. Relying on this, my submission would be that.
So show me that the impugn decision says panel has been expired, so I will not give you a point.
No, but then from what is my right there? If a quasi-judicial authority takes a decision, a selection committee form, they duly selected me. It has been sent to the authority for its approval by the Honorable High Court. They considered it not to approve on certain ground. If I can show from my pleadings that this fact finding or decision is erroneous, then I have a right to move it on. Where do I go? I cannot be remedialist, Lord.
Yeah, if the law does not give you right, you don't have right. Matter in
My submission is that
school, yes, school could have come.
then we got paragraph 27.
Yes,
Paragraph before that, 25.
yes.
Exhaustion or expiry of life of the medical panel cannot be done the right to the vaccines. That is, respondent police and the person by the illegal acts frustrated any object of preparing the vaccine by recommending against medical candidate by superseding the applicant getting both and position in the medical development as well as medical distancing. Action of the respondent and the police regard cannot be approved. These are the they will not paragraph 27.
Yes.
In the associate support, the applicant cannot be remediated on the ground expiring life of the panel. The applicant had no control of the respondent for a certification and the appropriate illegal action on the part of the respondent commission came to the notice of the applicant afterwards. Therefore, it cannot be said the applicant carrying with his right by appearing the subsequent system. This is the part that will die different. And next, that is not
এটা এগুলো রাখবেন সব, হ্যাঁ? এটা সব। ঠিক আছে।
Lord, I'm sorry to say, you have one copy. That's the only thing. You got. Yes, sir.
No, you give, what do I do, sir?
Yes. Hey, Lord, paragraph 14 to 70. Yes,
What is the citation?
citation is not 2000 page. Volume 7. Supreme Court cases. 270.
Paragraph,
Paragraph here 14 to 70. The paragraph 14 to 10. While no candidate acquires an individual right to a post merely because he has appeared in the examination or even found place in the city. Yet, the state does not enjoy an unqualified prerogative to refuse an appointment in an arbitrary fashion or to disregard the merit of the candidates as reflected by the merit list prepared at the end of the selection process. The validity of the state decision not to make an appointment with the
yes.
is thus a matter which is not beyond judicial review before a competent judge. If any such decision is found to be arbitrary, appropriate direction can be issued in the matter. The list
Read the facts, read the facts. Read the facts. Please read the facts from the beginning. This is the difficulty. Had there been a copy on my table, I could have easily got it. So twice I have to read. Once you will read, then I will. Oh yes, you're welcome. Let's read the facts.
We grant you which are these arrived out of an order passed by the High Court of Andhra Pradesh at Hyderabad, whereby the verification number sections are has been allowed, and the order passed by Central Revenue Tribunal Hyderabad Petition number status act. Senior Divisional Personal Officer East Coast Railway, Visakhapatnam issued a notification proposing to conduct a meeting practical proposal to conduct a meeting practical in writing in case for filling of vacant post of field practice in the place field of Sajjad. In response, as many as 12 candidates appeared in the case held on 13 October 2003. The result were what communicated on 22nd November 2003. Some of the candidates who failed to qualify made a presentation complaining about the manner in which the case was conducted, alleging that the defective typewriting machine provided to the place in the extract advantage vis-a-vis candidates declared successful. The successful candidates also appeared to have made impression of the authority. Impression of the authority. Impression of the authorities to go ahead and complete the selection process. That did not happen. OA number seconds and 1 5.
So what did not happen?
That did not happen.
What did not happen, sir?
That the impression of the authority go ahead with the interview and to complete the selection process.
So what did not happen, sir?
Successful candidates who also appeared to have made a impression of the authority.
So that selection process did not happen. Selection process did not happen. Right? Your case, selection process had happened. Yes, please go.
And to complete the selection process, if that did not happen, OA the 7 for 8 of 2006. If that did not happen, OA number 7.8 of 2006 was filed to the chair, but one of the successful candidates in the direction to the responding to proceed with the selection. In the meantime, the divisional manager of the National Railway had order on 12/2006 cancelling the typewriting conducted on by another notification the this typing test was notified to be made on for all the US service candidates who had appeared in the earlier case. By interim orders passed by the tribunal, the railway authorities were allowed to conduct the proposed second test in which the applicant to the tribunal also appeared. The applicant was at the same time permitted to amend the player in the case to assess the order passed by the divisional manager of the railway, cancelling the earlier test.
Is this the same fact, sir? With your case?
I want here is a recruitment process. One process cancels phase below that was telling. My case is that if a decision is otherwise that with to me, I appeared in the case. If it goes against me, only I have to wait for the intervention of the managing committee. That should not be the proposition of law.
So how does it help you?
No, I see the principle let down.
Principle laid down in a particular set of facts.
Principle is that it is okay.
Principle in the fact arising out of which the judgment was rendered.
But without principle laid down that it is right of employment is constituted. A process started. I dropped the panel. Panel was cancelled. Who will come to the honorable court?
Panel cancelled. Why?
On certain ground.
What grounds?
That ground has never accepted.
Illegal. It was illegal.
According to the act.
Correct.
Which I see.
So who has to come up against that? Who has conducted
I see a candidate who is right of employment denied. Certainly I can come.
All right, you come.
Who is come without? Certainly I appear in a different case. I have been denied illegally. I have a right to the post. I acquire right to the post the moment I participate in the post and subsequently panel prepared.
So show me that law. That the moment you participate for the selection process, a right accrued. A right accrued to receive an employment.
What is the use of advertisement for a post?
Inviting candidates.
I being a candidate, I appear, I participated in the recruitment test. There was a selection process. In the selection process, I was selected. It was a formality to get it approval. It was a formality and the rules. Selection committee is the committee who can select the candidate. Approval comes with the domain of the DI.
If the DI finds illegalities there,
That we are illegally there have the right. I am not saying so. But if I say,
who will challenge?
I will challenge because my right to the post, my appointment has been denied. We come forward with that. Certainly the school may come, may not come. I being a candidate who deserves, otherwise, had it been a case where I approved the candidate, I could get the appointment. That was the case about. This is the Supreme Court says, it is open to the dispute.
Suppose take a situation. The school
Not forward the name. Not forward the name, any name. If the selection is made, if the school not forward the name, that is the district.
That's right. I'm saying other way. I'm saying other way. That if the school does not require this post to be filled up now.
Where is coming?
So that I'm telling you, let me complete your answer to that. It might so happen that today the school thinks, no, I don't require these teachers or these employees. Right? So the school stopped challenging and proceeding with its own writ petitions. Possible? Possible?
No, we are subject to that. In fact, subject to that. In fact, it anticipated. Because of the fact law, initially school also challenged my right to the post.
So even if the school does not come forward,
even
the court will have to carry out.
My submission to the my right to the post, which culminated following a recruitment process, it cannot be at the base of the school. It is my right. It is my right to the post.
Show me that judgment that the moment you participate in a selection process, your right accrues to get an employment.
It is a subsequent process. I participated in list prepared by the selection committee. List was forwarded for the approval of the candidate. Now the school initially challenged, subsequently.
Show me that law. That yes, this is the judgment.
I am
Neither
of that.
But sir, the first judgment you referred to, according to me, has no relevance at all. The second judgment now you are referring to, here the fact is totally different. Paragraph 3 and 4.
That is my interpretation. I am on a proposition of law.
Yes.
Where my relying on Supreme Court judges, I say, if a decision has taken arbitrarily, if a decision is not in accordance with law, if it is perverse to finding of fact, I being a petitioner who deserves the appointment, who sought, he participated in the selection process, ultimately selected, and of course has the right to approach the honorable court, and honorable court can exercise judicial. Otherwise, I have no remedy. A person will go to the court, he will participate in selection, for any reason somebody will take a decision.
Now take a next step. Think of a next step. Suppose you are successful in this writ petition, right? The panel is declared to be valid. The school says, I am not going to absorb because I don't have requirement. Then again you will say the DIS.
This question where the school, I have read the school party have served there. Well, my God, why am I anticipating it?
I'm not anticipating it.
Is the school coming?
That's because I did not require. That is why very well. You use.
I have the experience to education case in 2000 recruitment process. Appointments is given in 2023. Number of cases in the school service commissions or other things, some parties participate, their appointment delayed. Now the candidate employer, thereby at the time when you can say that I will not accept you, vacancy lies. Still nobody has been given appointment. I have made the school a party. If not is so desires, I can give further notice. Has the school coming forward to say that I do not require?
Sure, next. For place, please. Next paragraph.
Yes. Paragraph 5, I was
Yes.
it is not in dispute that pursuant to the same notification and the order passed by the tribunal, the base case was indeed conducted in which all the eligible in-service candidates appear. Although the result of the state case has not been announced so far, the tribunal eventually dismissed claim number holding that test earlier conducted was likely cancelled in as much as the candidates were made to take the test in batches and no option was given to them to bring their own typewriter. The tribunal further held that although some of the candidates had made presentation and earlier advanced seeking permission to complete the request was not considered. All this according to the tribunal justified the cancellation of the typewriting change carried on an issue of a notification for a publicity. Agreed by the state order passed by the tribunal, Chief Satan said after declared successful in the first phase, filed a petition number Satan before the High Court of Honorable, which has by the order allowed the same. Said the order passed by the tribunal and also the order by which earlier case was cancelled. High Court further directed the respondent to proceed with the selection process, pursuant to notification and the practical test conducted on the center present appeal has noted above assess the correctness of the state order. We have heard the learned counsel for the party founding proved that quoted for the High Court has found force with the order cancelling the earlier case primarily because the same was unsupported by reasons whatsoever the state order internal. Third, my lord, what we when I speak on it. Here the participant candidates have come forward. Also, here the candidates have come forward concerning the selection process. The practical test conducted, I am reading the practical test conducted, I am speaking on this. The High Court was also of the view that no reasons for cancellation of the test has been recorded on the file. Honorable Court actually maintained for the part of they would not be supplied to the file to the price of the Gathering the state of the way, the cancellation of the test was not according to the necessitated by any irregularity in the conduct of test or any malafide issued to the state. In the absence of such information, the cancellation of the examination was affected unsustainable declared the action. There is no quarrel with the well-settled proposition of law that in order passed by a public official exercise with administrative executive standing law must be judged by the reason stated in order or in any mode to try continuously maintain. It follows that infirmity arising out of the absence of civil by the authority passing the orders to each services in a different private court where the validity of such order is under challenge. The legal provision is settled by the public order. Public way in exercise of federal authority cannot be constituted by difference in subsequent given by publisher looking the order. I can skip over this.
So here no reason was assigned.
That's in the given case.
In the given case, High Court did not assign any reason.
The reference may also be given the reason of certain the stated equal arrangement matters the statutory function to mix an order based on certain ground. Its validity must be judged by the reason so mentioned. It cannot be supplemented by. I also taking this one. Latter decision of the court certain such. I rely on the decision in the court of Union of India certain such. Mr. Maluk also say argued that challenging the order cancelling the test was legally untenable as no candidate had any legally enforceable right to impose until he was selected and order of appointment issued in his favor. Cancellation of the selection process on the ground of malpractice would not be therefore be subjected to this was the argument subjected to judicial scrutiny before the court at the instance of the candidate who had even found the place in the selection, who had not even found it. But here I have got it found the same. A constitutional bench of this court in Satansa had an occasion to examine whether the candidate seeking appointment to a civil court can be regarded to have acquired an indefensible right to appointment against her merely because his name appeared in the list of candidate for certain. And certain is posted in the negative. It's also observed. It is not correct to say that he a number of vacancies notified, adequate number of candidates are found filled, the successful candidate according to indivisible right to be appointed which cannot be legitimately denied. Ordinarily, the notification merely amounts to an invitation to qualified candidate to apply for recruitment and on their selection they were acquired that report. Unless the relevant recruitment would show the state is under no legal duty for any vacancy. However, it does not mean the state has the license of acting in an arbitrary manner. This decision not to be the vacancy has to be taken bona fide for appropriate reason. And if vacancies of any of them are filled up, the state is bound to respect the competitive merit of the candidate as declared at the no discrimination can be permitted. Current position has been compared to follow the code of finding is current, no conditions, sir. It is evident now when I was listening to
So up to this, the Supreme Court, Honorable Supreme Court proceeded that there was no reason for cancellation shown.
no, at least we know the paragraph saying, cheating paragraph. Supreme Court never said a candidate cannot come to the. At least, paragraph Supreme Court in no point of time said a candidate had no right to approach the court judicially. I have not found any of this. Only on that Supreme Court has gone to the matter and said
That principle will have a go by that mere empanelment will not give a right unless the appointment letter comes.
so that is the last time. It is evident from the above that while no candidate acquires an indivisible right to a post merely because he has appeared in the examination, even found a place in the selected as a might be. Yet, the state does not enjoy an unqualified prerogative to refuse an appointment in an arbitrary fashion or to disregard the merit of the candidate, as reflected by the merit appeared at the end of the selection process. The validity of state's decision not to make an appointment is a matter which not beyond judicial review before a competent court. If any such reason is indeed found to be arbitrary, appropriate direction can be. This is why.
So why is this arbitrary?
Yes, if you not.
No, not in your case. In this judgment, paragraph 14.
No.
What was the arbitrary part?
Here, one process started cancelling another process.
So what was the arbitrary part here? Paragraph 14.
Paragraph 14.
What was the arbitrary part that the
paragraph
court said?
What is the arbitrary part that is not referred to?
Not referred to. Up to 1 to 13, the entire sets of paragraph.
I join you, my lord. Therefore, court has found something to be arbitrary.
What was that something? 1 to 13. Court has found the arbitrariness. What is that arbitrariness?
Paragraph 15 also kind of.
No, 1 to 13, you first tell me what was that arbitrariness court found and made an observation in para 14. What was the arbitrariness?
Because that will come subsequently, probably.
So 1 to 13, there is no arbitrariness. What was the arbitrariness court found according to the Supreme Court in paragraphs from 1 to 13?
Onwards I have 14 in the principal letter.
14 is the principal laid down in the light of what?
In the light of the fact
1 to 13?
In a given case,
14 was the principal laid down.
Yes.
In the light of which facts? Stated in 1 to 13?
Let me come this paragraph. Let me come to this paragraph. What is there? To the same effect, that's why my submission to paragraph 14. But it is not beyond judicial.
I am absolutely with you.
Yes.
But what was the arbitrariness that led the Supreme Court to say, allow the judicial review? From 1 to 13? So what was that arbitrariness, factual arbitrariness in 1 to 13?
Paragraph 16 have to explain. To the same effect is the decision of the court in circumstance. Where again the court reiterated that while a candidate who finds a place in the select list they have no vested right to be appointed to the court. In the absence of this, we use entirely linked to the same. he will still be accused by the non-appointment if the authority comes and act arbitrarily or in a malafide manner. That was also a case where the selection process had been cancelled by the Chandigarh administration after receipt of complaints about unfair injudicial manner in which selections of the candidates for appointment and candidate in CPM were prepared by the selection board. An inquiry got conducted into the state complaint, proved the allegation made by the complaint was true. It was in that backdrop, action by the Chandigarh administration was held to be neither discriminatory nor unjustified, as the same was being supported by valid reasons of cancelling.
By valid
By valid reasons for cancelling what was described to the court as to be a dubious selection.
So what was the arbitrariness?
Yes, that might also to show.
What was the arbitrariness in paragraph 15?
Paragraph 15 and 14 and 15. Why at
14
the time
and
of the
15.
case, my lord has asked me a question. To apply your lordship, whether a candidate is my nature can come to the honorable court.
Sir, in this judgment, the Honorable Supreme Court said, if the arbitrary action is
applying these principles to the case at hand.
at hand.
At hand. Yes.
So what was at hand? What was at hand? What was at hand, sir?
Allow me to just read it. Applying these principles in the master magistrate to this case at the head, is saying that while the candidates who appeared in the typewriting case had no indisputed right and absolute right to seek appointment, yet the same did not give a license to the competent authority to cancel the examination and the result thereof in an arbitrary manner. And this with the candidates who were otherwise eligible for appointment and who had appeared in the examination that constitute stepping aid. It was stepping aid of a possible aspect. I also guessed it. My right to the post is a step and aid to the appointment.
What was the arbitrary action?
That here.
No, in this judgment, that
This judgment.
what was the arbitrary action?
They have illegally. It was a decision of the tribunal asset. Whereas it initial written test was cancelled by subsequent on the case. Some parties came forward that tribunal.
What was the arbitrary action?
Arbitrary decision to cancel.
What was the arbitrary
That
action?
process was cancelled.
What was the
That
arbitrary
process
action?
was cancelled and relocated.
What was the arbitrary action?
They not
The arbitrary action was without assigning reason.
That is not only. That is not the only.
That is the
Why? That is not the only.
sir. In this judgment, that was the only.
Therefore, I have a right to approach. My take it from me. I have a right to approach. If the might stick to this, that only on the ground of non-assignment of reason minors can interpret as another thing. But I have a right to come.
You don't have a right to come.
That is minor interpretation of my my interpretation is otherwise. I am relying on very that. But subject to my limitation, I am.
No, it's all right.
Applying this principle to the case at hand, there is no saying that why the candidates who appeared in the right trial had no individual and absolute right to seek appointment. Yet the same did not give a license to the company to cancel the examination and the result thereof to the defendant. The list with the candidates who were otherwise eligible for appointment and who had appeared in the examination that constitute a statement made on the possible appointment in the were entitled to these the selection process was not allowed to be curtailed for malafide reason. It is true that Article 14 of the Constitution strikes that arbitrary and antithesis of the guarantee contained in Article 14 and 16 of the Constitution. Whether or not the cancellation of title was arbitrary posted to the court shall have to examine. Once a challenge is mounted to any such action, no matter the candidate would have any right to claim appointment, they should have advertised. I place on this paragraph solely on the ground that it is not beyond judicial decision. Because I, being a candidate, participated, my right has been forfeited. Therefore, if in a decision case, now he should allow me to go through the decision. If I can show from the that if arbitrariness also defined in paragraph 13, 16, 17,
What are the arbitrariness?
Twenty three and 30.
Yes.
It's so heavy, sudden cited by that purport of this cited.
No. Where you are reading? 23. 23. Read 23. Read 23. Read loudly.
Arbitrariness in making of an order by authority can manifest itself in different form. Order which you mind by the authority making the order in one of them. Every order passed by the public of the mark restores due and proper application of mind by the person making the order. This may be evident from the order state or the record contemporaneously maintained. Application of mind is the way demonstrated by disclosure of mind by the authority making the order. And disclosure is based done by recording the reason that make the authority pass order enforcement. Absence of reason either in the order passed by the authority or in the record contemporaneous mention is clearly suggesting of the order that being applied is legally unsuccessful.
So what is the arbitrariness?
He has not devoid of truth. He has not applied his mind to the actual.
What is the arbitrariness, sir, in this paragraph? Last sentence, please
He has
read.
to apply proper mind is arbitrariness.
Absence of?
Application of mind.
No, kindly read it.
Yes.
Kindly read. Last sentence.
Application of mind is the base demonstrated by the disclosure of mind by the authority by making the order. And disclosure is based on by recording the reason that led the authority to pass the order requested. Absence of reason either in the order passed by the authority or in the record contemplated mentioned is clearly suggesting order to be arbitrary, hence clearly.
So what is the arbitrariness?
My lord has to be together. My lord is to be isolated.
All right.
Because we may hasten to add that paragraph 30. While application of mind to the material available to the competent authority is an essential prerequisite for the making of a valid order. The requirement should not be confused of the sufficiency of such material to support any such order. Whether or not the material placed before the competent authority in the instance is sufficient to justify the action taken by it is not an issue before us. That aspect may be assumed important only if the competent authority was shown to have applied his mind to whatever material was available to it before cancelling the exam. Application of mind is a threshold requirement for a valid order is conspicuous by capturing the question whether the decision was reasonable having regard to the material authority rendered academic. Sufficiency or otherwise of the material and overall admissible to submit decision valid to what is review may be otherwise depend on the facts and circumstances each case. No hard and fast rule can be formulated in that regard, nor to be proposed to in the context of it. If I can so found
This is on merit of the order.
yes, I am telling you the merit of the order.
Correct. So first to challenge the merit, you have to cross the hurdle of your locus.
Yes, I have submitted.
So kindly first satisfy me on locus that you have a right to challenge.
In that sport, I have this judgment according to me will support my case, and another judgment I am giving.
Yes, sir. On your locus, right?
Yes.
Give me citation.
Yes, I am beseeching your lordship to
Citation.
think of one thing. All these cases,
Right.
the Supreme Court,
Where the candidates in what facts?
the candidates came forward.
Yes, under what
They have
facts?
no decision to do.
All right.
Supreme Court
Let me give you the citation.
issued 1995 SCC supplementary volume 2 page 2.
No, one second. 1995.
SCC supplementary volume 2 page 2.
Yes. Page, paragraph.
12.
First, show me the facts.
Exactly. This appeal is when the election of candidates for appointment to the post of duty and invited accepted authority made by selection headed under sub-rules of the Certain Tax Tribunal. The selection board prepared a panel of selected candidates who included the name of the applicant and sent its recommendation on January 25, 1990 to the central government for consideration under Certain. The central government did not make any appointment. They issued fresh advertisement on Certain and invited the application for the same. The applicant filed original application before the central tribunal, seeking a direction to the respondents to appoint the official income section of the tribunal on the basis of select and prepared by the selection board in 1990. Tribunal by judgment stated that this means that it is approved by the official tribunal. The appellate is an advocate having registered himself with the bar at DD 1991. In September 1987, the law and justice issued an advertisement inviting the application for free post of judicial company. One post was third was type pension and the post was from the general category. It was further stated in the advertisement that three posts were included in the picture but were likely to continue. And further that number of vacancies were only approximate and likely to alteration. Before the tribunal also approved the stand of the central government that advertisement was not for which were anticipated to act. The appellant applied for one of the posts in response to advertisement. The interviews were held on January 12, 1998. It is not disputed that selection board sent its recommendation on January 25, 1993. We have been informed that at the bar that Mr. Satansa had number 1, Mr. Satansa number 2, and number 4 of the select panel recommended by the selection board. The selection board could not find any suitable types as suggested for the advertisement. According to responding, the reserve vacancy was re-advertised on March 20, 1998 and was subsequently filled up on January 5. The government of India had filed counter by the it is about that the vacancies anticipated during the year 1989 were all on the requirement of the we further say that the two vacancies belonging to the general category attempted to arise on October material and age of determinant of the first place raised by the government the counter agency further the government of India further states that two vacancies we cannot anticipate available because students are educated because of the another short version here is that difficult to complete that two details available on August 14, 1980 and June 5, 1982 respectively to offer to the candidates on the select running the accommodation that may be compared. The central government has, however, continued that out of the two one is to be kept reserved for one citizen who are in position according to the government, in India. On its side of school procedures, she is the offered at a year tribunal. It's presumed that the school procedure, the post was prepared for me at the time. We do not agree with the contents of the system. All all according to the constitution of the but until they give the existing vacancy, Indian minimum must have been appointed against the existing vacancy. It could not have been appointed but the ENC came to only be placed in the post we are careful of the view that there were two clear vacancies by the authority in the application. As you know that there are only one vacancy at the same vacancy. There was cross dealing on the part of the community action. Vacancy became developed from other states in 1919. According to the chart based on the report of civil government, action initiated on 2019. We fail to understand the problem raised by the expression initiating action that the character and anticipates the issue has to be worked out as soon as the combination of the selection board was received. No material has been placed on record, and all was brought to our notice to show as to why central government would not initiate action as the vacancy was available. Needless to say that the combination of the selection board, headed by sitting yard of the East Board, was gathering drafts and reports of the council in 16 January 25. We take serious view of the matter and we direct that any recommendation of selection which is headed by a sitting yard from can be once there is recommendation by short selection board, nothing should be intended. The recommendation and a non-consideration by the appointment committee of the cabinet, the minister secretary, that is the publication, and the duty bound to process the recommendation by giving top priority and place the same before the in the present case, though action was taken to be initiated from February 1918, the first piece was reconsideration. We direct the recommendation of selection notice that must be placed taken by the central government that offered a permanent was seen on a joint and the consequent offer was cancelled. There was no further offer. Effort to the movement. Awarded number 2, the selection was similar. The applicant had been filed similarly. This student was a member of the Delhi Judicial Court, was posted in that circumstance. At the hearing of the appeal, we are informed that sentence theory short for voluntary fuel. In Canada, at this stage, the method of the non-speaking formula. Paragraph 11 below. The selection panel. The tribunal dismissed the application by the MP data on the following definition. The selection panel was merely a list of persons found suitable. Does not close the application to the act of appointment. The recommendations of the selection board were article not enforceable by issue of the list of members by the court. The letter of Ministry of Home Affairs which extends the right of tenant to not eligible to the immediate day. In the circumstances, the right of the family is moved in 14 months, except expired in July 1999. It is no doubt that the person in the select panel has no right to the appointment of the board for which he has been selected. He has a right to be considered for appointment, but at the same time, the appointing authority cannot ignore the selectee or decline to make the appointment on its wings. When a person has been selected by the selection board, and there is vacancy which can be offered to him, keeping in mind the view is very position. Then ordinarily there is no justification for executive appointment. There has to be a justice reason to decline appointment a person to be on the select panel. In the present case, there has been mere action on the part of the lower person not to talk of justice, but giving us why appointments were offered to the candidate. They take some of the particular paragraph on why we got it. Therefore, we not have a right of consideration. My right of consideration has been negated by the impending decision. I can approach the government if I can show to my law that the decision making or the decision making is beyond the purview of the law or otherwise pervert. But I am a candidate. I participated. I am not supposed to know the technicalities. I am a candidate who was asking for appointment, who already advertised approached on the opportunity, participated on merit. If allowed, my lord, I can show how these things are going, how they have been, my appointment has been made. That is much. But I will not, without going into the technicality, my lord, allow me to exit, or my lord, if lordship my submission, if lordship thinks, my lord can refer to the commissioner, he should scrutinize everything. Allow me to substitute, if it is found on scrutiny that I have a right to them, otherwise I am duly selected, he can offer appointment, he can send it for my lord. I am not asking my lord go into every question. But why I refer to Rule 20, there is a scope of the commissioner to go into the question.
Before, by,
Regarding selection,
who can question that? Rule 20,
obviously that is on the part of the management. But when the committee came to German, this thing happened. Managing committee was initially very much active, and matter was hard. If you like, I have to watch every petition. I have
so today, even if the managing committee's writ petition is dismissed for default and the managing committee
there
is not,
I cannot make it.
that's right. So if the net result is managing committee is not pursuing the cause.
At the time, they pursued it.
We pursued. They pursued.
Change of management, but I am approaching on my own accounting. I want an appointment. I am an unemployed person. I am seeking an appointment. I want appointment. I am approaching for judiciary from the ground. It has undue consideration where rules are not followed. The documents are not properly verified. Each and every line I have countered in my every point I have given an answer. Every point. I satisfy your lordship on every point that how things have gone. Well, visualize the position of a person who where this person can go.
What to do if the law is defeated?
Fast, shortcut.
No, if the law is against you, what to do?
Subject to not, but my lord, interpret not. I found all the papers. There are candidate who did not give the appointment, they have to apply. All cases. And court has interfered in the matter. Not that court has shut it down, that no, you have no right.
Next judgment.
I don't know.
No further judgment. Yes. You have concluded.
You can put the question of maintenance.
Maintainability.
I have no other answer. My submission is to the extent that I am a candidate, I can approve.
Where is Mr. Vishu? Where is the land government? Pension government. Proceed. Proceed. Your name? Ask Mr. Vishu to come and yes, sir.
My narrator cited about my father not.
Take it.
But here also, I am voting continuing for the jail.
I told you the judgment what you want to rely upon. So, and you take it. Get ready. I'm coming at 2. At 2.
3 or 3.
No. No. I don't. You know my practice, Mr. Roshu. I do know my practice. I don't maintain it like that. 3 p.m. 3:45 to No, I cannot, sir. Ask any of your junior to do. I don't mind. Please do it. And it's very well. I'm sitting here and now. I will release you. You complete in the meantime. After that, you get the other matters done. I don't mind. Complete.
Here, I am only not.
You take these books. Everything to go.
That I am not. That right. We are also there. I will give some time. I will give you lots of moral lordship. Or not, I will not. What's the
Very excited.
That was that I have given lots of then I have not. Maybe tomorrow or see whether.
That already you consider and come back. Ask. না এটা রেখে দিন আচ্ছা
I have.
yes আচ্ছা SCC give me a Xerox copy of that SCC এই দুটো আপনি এখানে রেখে দিন আর ওই হ্যাঁ বইটার জেরক্স কপি give it to me পুরো তুমি দিয়ে যাবেন ম্যাডাম দিয়ে যাবেন আপনি নিয়ে নেবেন you give it to my officer madam she will take it আপনি জেরক্স গুলো রেখে দিন এই নিন এটা রেখে দিন এই নিন ম্যাডাম এটা রেখে দিন সব গেছে রেখে দিন I don't do that, Mr. Bushu. See, I don't do that, sir. Then if somebody will say 10:31, somebody will say 1:12. Ashu. In the facts of this writ petition, the court raises the first question of the petition. In the fact of in the facts of this writ petition, at the outset, the court raises court raises a question as to the locus of the writ petitioner. To maintain this writ petition. First, whether any vested right of the petitioner has been infringed by the act of the state authority as pleaded in the it is pertinent to note, it is significant to note that the other writ petition being WPA 5800 of 2011, referred by the school authority, has already been dismissed for default on January 10, 2020. First. Mr. B.N. Rai being ably assisted by MS Shekponna Rai, learned counsel for the petitioner, has concluded his submissions on the question of, in support of the contention that the petitioner, in the facts of this case, can maintain this writ petition, and this court, in exercise of its power under Article 226 of the Constitution of India, can venture for a judicial review over the impugned order dated. Yes, madam, over the impugned order dated. Impugned order dated. Page 45. Page 45. Over the impugned order dated.
That's the last page 27. Last page 27. Last one.
Yes, it's January
31st.
31, 2011. Annexure P10 hold at page 45 to the petition. কি বললাম? হ্যাঁ,
Yes.
Power. Mr. Rajpal Prasad Doisho, an additional government leader, pays for an accommodation so that he can consider the judgments cited on behalf of the petitioner and then revert back to this court and then make his submissions on the next day. Full stop. For the ends of justice, such way stands allowed. Stop. The petition shall appear কিভাবে আছে এটা দিদি? Under the given forwards. On February 8, 2024. Full stop. Please be there. 8. Please be there. Please assist this court. And whatever judgments, if you wish to cite, bring those with Xerox copy. And madam, you give that Xerox copy. But on the last day, she argued very good. Excellent.
Plan and improvement officer to evaluate and committee.
54. What is the matter about, sir? Take the mic.
One of the lead staffs.
Action.
It was recognized.
Mm.
And but the dispute meeting is by the application made by the petitioners that false meeting is submitted or other false on the government established. The dispute was not satisfied, the also related that we either are to contact and the assistance of the authorities after giving opportunity notice to all the parties. Everything has been completed, report has been printed, not yet effort, but to follow it. Was what the team
Copy soft. Oh, unless apart. Unless.
tomorrow.
Fast over for the list. On the prayer of Mr. Sutitto Dash. Thank you. Body judgment of Sarvapur. On the prayer of Mr. Sutitto Dash. Now, on the prayer, pursuant to the direction made by this court on December 14, 2023, the rejoinder to the supplementary affidavit in opposition on behalf of the petitioner affirmed on February 2, 2024 is filed in court today. The same is taken under it. Full stop copy has already been served upon Mr. Chaturvedi, and counsel for the school. Yes. What is the matter about? Just remind me, petitioner, then I will hear you. What maintainability?
This is the repetition of 2018 regarding non-payment of salary. Now, thereafter, the disciplinary proceedings was initiated, termination order has been. In the second round of litigation, that termination order has been challenged. Ultimately, matter with the honorable division bench and the honorable division bench was that entire disciplinary proceedings and the termination order with the liberty to the school authority to proceed the matter in accordance with subsequent rules. Thereafter, the school authority again proceed with the disciplinary proceedings, though not in accordance with the subsequent rules, but ultimately I have been terminated from service. Now, in this picture, subject matter is the non-payment of salary from September 2018 till the day of dismissal. The subject. And in this picture, my largest senior friend has raised the point of maintainability because the reality. And according to their submission, that the picture is not maintainable, it is a clear. And so far as the point of mutability point is concerned, this was not taken in the main original affidavit notice.
Doesn't matter. But the maintainability was not also taken
At the time of
when the
admission.
first writ petition was ordered.
Second petition was ordered. At
This
that
is the
point-
third one.
No, this is the first petition in the
The writ petition which travelled up to the appeal court,
second.
second writ petition. There it was not taken.
No,
There it was not taken.
in the first petition, when the petition was admitted,
What was the first writ petition? Oh, first writ petition, you said that the disciplinary proceeding was bad. Initiation was bad.
In the first petition,
Was bad because it has to be in the new rule, under the new rule.
in the second.
First writ petition,
First petition, this is the first petition, this is the non-payment of salary.
after this, the second writ petition was filed. Okay.
Because I have paid for salary, that is why the regular disciplinary proceedings was.
All right. So what was the? But this writ petition was filed claiming salary for the period when the ultimate termination order was passed, pursuant to the division bench, after the division bench.
This is a subsequent cause of action.
When?
The order caused by the honorable division bench.
The termination after division bench.
That termination letter has been issued in the month of November. November 2022. We have annexed it in the supplementary 24th September 2023. In my supplement.
This is Ashish Kumar Tiwari. No.
No. September 24, at page 34 of the supplementary meeting.
Also. DV order dated
Termination letter.
DV order. Division bench.
June 3rd, 2022.
June 3rd, 30th June.
2023.
And termination order.
Termination letter dated September 24, 2023.
Your claim in this writ petition during which period? First prayer is
February.
first prayer A. Can you come to page 37?
Presently,
Prayer A, administrator. Then prayer B, to release the arrear salary of the petitioner for the month of, from the month of February 17
2017, want to the service mark.
till the date of termination,
The date of termination.
24th September 2023. Huh?
In law, I understand.
Right. Here deposit has been made,
No, in this matter, the deposit has not been made.
directed to be made.
There are also no certificates.
Or
And,
Better.
and another one more interesting thing is page 35 of their supplementary activity opposition. By data dated December 12, 2023, they have issued this letter. The effect of this letter is that I illegally drawn the salary, therefore I am directed to refund us.
till for which period?
That period has not been mentioned, my lord, but in that
In the period of service
in that
from the date of appointment.
and my lord, one interesting feature is that the termination letter was issued on September 24, 2020. Therefore, from September 24, 2023, the employer-employee relationship has been scrapped. Thereafter, this letter, which was issued on December 12, 2023, has been omitted to that.
That's a different, not to travel so much.
But
Mr. Chaturvedi,
Right.
yes, what is your point of maintainability? 1 second. Respondent number?
But I, you know, we have this one next number, I need to put it.
Maintainability. Yes,
And before I address my lord, on the material, that two rounds of litigation were ever in. The first round of litigation is this one. This was filed in 2018. When the petitioner was placed under suspension. The proceedings was under. The law at that time was that there were two stages of it. In that, the first stage is not a show cause notice is issued, to which not a reply is received, not an inquiry is received. And a dossier is prepared because central of board for not on the board approving the proceedings, not the second stage comes in. When not the managing committee vested with the power under Rule 28 of take appropriate decision. But this was not sent. But the board it did not approve. It did not approve, not in violation of the rules. In violation of the rules. Hence, not the second period was filed by the school authority. By the school authority. Challenging the order of disapproval. Disapproval of the proceedings.
board did not approve the disciplinary proceeding.
Yes.
So you challenged.
Disapproval was challenged by the school. But the petitioner will not also file a report seeking implementation of the law. These two petitions won the second round of petitions, which were heard together. Not the letter single judge will not pass an order saying that in view of the new rules, there is no scope for any approval or disapproval. By the time the school had sought the approval, there was no requirement under law for the school to have sought for it because the new rules had come into effect. And under the new rules of managing committee is only to intimate rather than seeking an approval. So the decision is rightly taken. It is an act of the
Not in so much of words, because I am hearing the maintainability. First writ petition approved your disciplinary proceeding.
Did not approve.
What did not approve?
First petition is this one.
No. Second writ petition
Second petition,
ultimately culminated into an order of appeal court which said disciplinary proceeding, the then disciplinary proceeding was set aside and liberty was granted to file afresh to take steps afresh following the new rule.
yes,
That's all.
yes.
Nothing
yes.
more to trouble because I'm hearing the mental ability.
Yes.
Now,
This was not the second. This was the second. But only
so show me from the judgment of the trial court of the first order in that writ petition, second round of writ litigation, and the appeal court that you took the point of maintainability as well.
I was coming to. Why we got the point of maintainability was not required to be taken is because that petition was very much maintainable. Why? Because Lord, the action of Lord, a board which is amenable under Article 12 was the subject matter of challenge
Who challenged that?
by the school,
School. And the
And-
second writ petition by who?
by the petitioner seeking implementation of an order passed by the statutory authority.
Implementation by,
Implementation, yes, it's against me.
then was this point not to be taken, required to be taken?
It was not because there were not two writ petitions. One challenging an order,
Maintainable.
one seeking an implementation.
Maintainable. First writ petition by the school challenging the order against the board.
My point.
200% maintainable. This is the 2A writ petition because second stage is 2B writ petition by him seeking enforcement of this the disapproval by the board by the school.
Implementation will have to be by the board because the board can call upon the school to take a consequential action. It is board order. Board will have to implement. So what the petitioner was seeking is an implementation of an order by the board of an order which was already passed by the board.
So it was.
Saying that despite your order, the school will not comply.
Show me that prayer in the same your writ petition. What was the prayer in your writ petition? Second writ petition.
My
Please. Your writ petition was maintained, challenging the disapproval of by the.
yes.
Now, what is his writ? What was his writ petition prayer? Then how can I assess whether this point of maintainability could have been taken but not taken? Forget it. It's a point of maintainability, question of jurisdiction, anytime, any stage. Following 54 Supreme Court, anytime, any stage. Even at the stage of execution, no issues. But I need to look at the prayers in your writ petition, second writ petition, that whether in the light of those prayers, this point of maintainability could have been taken but not taken, or not required to be taken at all. If not required to be taken at all, situation is otherwise is different. If could have been taken but not taken, situation is different. Whoever estoppel, constructive res judicata, whatever nomenclature you say, the different issue.
The sum and substance of the prayer I have not explained to you.
I have to see this.
Yes, if I not direct, I shall. I think it has included enough to bring the petition. You do not cite either of us.
Because the moment you have to face with this question of maintainability, then it would have stuck for the first time in your mind. And look at this was my prayer in my first petition, previous writ petition, where maintainability was never raised. He accepted the writ petition to be maintainable. Then an order was passed in connection with that writ petition. You proceed with the disciplinary proceeding afresh. He carried out that. He acted upon. How can he take this point of maintainability today?
But that was a later proceeding again, subject to being corrected. Because that was a later proceeding. Because any principles of restitution will have to apply in a later proceeding. if I'm my understanding of it. This is of an anterior,
Anterior in number,
anterior in time.
anterior in time, very well. Anterior in time, but this is not a principle of stay of suit. This is a question of simplicity or whether the point of jurisdiction
In
you
another
have
proceeding,
taken which is decided earlier, and you have accepted that. Then again, whether even if in an prior proceedings, which is going to be decided after that decision, of course, it has to be seen.
yes, I was only saying from my but this is the conspect. That's it.
Oh yes, yes. That, since you have said that, that is why it struck my mind. Then let me see the petitions there.
Yes, I shall, either of us or both. But I was only saying, kindly look it up from his point of view. That the prayer there was that the board has disapproved whatever the school authority has done, and without the board approving it, the school cannot move a step further. All that rigors that has been undertaken at the behest of the school and the trial and tribulations faced by the delinquent teacher, it all is relegated to a zero.
Not
This
zero,
was
not zero, sir. Relegated to a zero. Then again, +1. That you proceed further in accordance with the law.
no, that was not the liberty granted by the board.
Not the board.
But I
Appeal court.
no, I am at 2A and 2B.
2 and 2B.
Yes. 2A, 2B.
2A is your challenge against the disapproval.
Yes.
1 second.
Fine.
200% maintenance. I have no doubt in mind. Now 2B. Implement this disapproval.
Yes.
Implement this disapproval. Upon whom mandamus should be issued?
But the mandamus will be issued on the board to call upon the school to take appropriate consequential decisions. So it will be a decision of the board.
Now, that's why I wish to look at this way.
Yes. So that is that was a scope. That was the scope. And in a repetition where the self-same order is under challenge, to take a point of maintainability that one of the repetition is not maintainable. Although the self-same defense can come by way of an opposition by the petitioner, that was two technical possibilities.
No, here not. It depends upon 2B writ petition. Prayers in the 2B writ petition.
Enforcement of the order.
I will have to look at it.
Yes.
The manner and mode, it was allowed.
Yes.
Because really, in effect, 2B was allowed by the appeal court. The disapproval, everything was set aside and directed the school, you proceed afresh. So in effect, 2B was allowed, 2A was allowed, your prayer was allowed. The disapproval was set aside. Otherwise, he could not have proceeded afresh in terms of the new rules.
Yes.
So,
the prayers were allowed.
right. So your writ petition was also allowed. His writ petition was also allowed. Right? Now, the moment your writ petition is allowed, disapproval stood set aside. Clear enough. Wash it away. The moment his writ petition is allowed, disapproval is set aside but not implemented, but directed to proceed afresh. Right?
So my repetition was allowed in its entirety.
Right.
His repetition were limited.
Limited. But the moment that writ petition was allowed to be kept on the board, to be held as maintainable only, otherwise this no order could have been passed in his writ petition. That's why I want to look at the prayers, and thereafter the school has acted thereupon, accepted that order, proceeded with afresh in a disciplinary proceeding, second disciplinary proceeding. Now I have to look at the reliefs claimed in the second 2B writ petition.
And the reason network.
Division bench order, yes, but I take it that division bench has said, set aside everything, it has cleaned the slate, and then again said, proceed afresh.
I sees why the division bench order is because the learned single judge dismissed his writ.
No, I will take both the orders. I will see trial court order, division bench order, and the 2B writ petition and 2A writ petition. The prayers. I look at those. I look at them and then this point of maintenance.
Look, the reliefs there. No, I said come. The reliefs there and the reliefs here are of such nature that such a objection with regard to maintainability can be taken here because law is clear that in so far as discharge of a function which has a public law element,
You will be relying upon St. Mary's.
St. Mary's and some judgments of our court division bench, which will not have laid down the law that in respect of these are not basically in the domain of the contractual obligations. Whether in respect of a private school, this would formulate as a part of your discharge of a public law function or not. Does it have a public law element or not? In respect of a school, this school, another teacher, this honorable court, the coordinate bench has said that he wanted salaries and emoluments, said the reputation again this school. This is the case. I shall rely on.
But if there is a violation of statutory rules that the disciplinary proceeding was bad in law.
The question is, proceeding is one part. What when this petition was filed, the proceedings they I would say yet in an embryonic stage, not yet formulated, not ripened enough. Because before the approval is granted, nothing crystallizes in favor of either of the parties. It's only when the approval is granted by the court that respective rights and obligations they crystallize.
So, but the moment it was disapproved, your right accrued and you challenged.
No, my right under law to challenge that is separate. I say right under the statute that we are governed by.
No. If the board has a power to approve or disapprove,
yes,
automatically the either way it is challengeable under 226.
Yes. No, I said my right under constitution to challenge without an order which is amenable to get jurisdiction, that is not a separate part. I say rights under the statute, not under the constitution. Right under the statutes crystallized only after the board either approves or disapproves.
Huh?
Now, this is at that stage. This is at that stage. So, here his claim was only confined to
No, this is not at that stage.
2018.
Admittedly, the division bench passed an order on June 30, 2023. And you passed an order of termination on September 24, 2023. Now tell me, simpliciter, don't look at everything, anything. What is the law? Till the time September 24, 2023, he was terminated. Is he not entitled to get his salary?
But I answer my question. Because I see it. That's the court would first look into not the petition which is presented before them. And not the report is definitely entitled to look into subsequently. I say, let us see the construction of the petition based on which I have raised the question of maintenance. Now, what was not maintainable but at its inception would not, by the subsequent act, become maintainable before what that law by law do. What is not maintainable at the inception cannot be infused with maintainability by subsequent action. So, this repetition had not the player claiming salaries. I say that this claim of salary is within the domain of contractual obligations is not maintained. If my argument before my lord, if it falls on the floor, then he is entitled to salaries. which he would be entitled to whatever period that my lord determines, whether it could be confined only to the extent as prayed for in the writ petition, or will it stretch beyond the period as claimed for in the writ petition.
You see clearly in the liquidity.
Yes, yes, and keep on going.
There is no it was a close-ended, open-ended prayer.
Yes, but I say,
It was an open-ended prayer.
but I've seen it. And his prayer here, Mira, has already been met.
It's not scalar, it's vector. It is not a close-ended prayer, it's an open-ended.
I have one. Now, why will not I say that these are two periods? I reminded I made this submission before my that his claim in prayer B will have to be segregated into two parts. One is anterior to the proceedings, and two, during the pendency of the proceedings. Now, with regard to the period anterior to the proceedings, the criterion may be different. Now, once I say that your appointment is bad in law for this reason, that
All time to come.
yes,
All time to come.
and we have practiced fraud. Our division bench says that the employer is entitled to claim recovery of wages, and in this case, the entire period of wages was directed to me. Because I came across a judgment where a division bench directed recovery. Supreme Court in exercise of powers under 142 said that is going to court hardship to that extent it is released. But the ratio is that it is recovered. I come to it. The only issue is that these two separate stages of claim, one anterior to it and other post the
Division bench order.
post the initiation of the proceeding. Will have to be segregated and my lord will decide that. But the issue of penalty, as my lord said, my lord would look into the previous opinions. I shall. Because another issue, I speak my mind aloud, my knowledge becomes clear. If an authority is vested with a power, and action in law done by it in the exercise of such powers, then the presumption it carries with regards to its right. And the order of termination has not been changed. So he is in the teeth of the order of termination, whatever claim he is making, he is making.
No. He is making a claim up to the date of termination, till the date of termination. The moment they terminated, relationship snapped. So till it is snapped, he is entitled to the benefit. That is his case. Show me the law
And
that he is not.
yes, and something that if the appointment is based on fraudulent criterion, then I am entitled to and I have demanded. So in this, I have demanded in the exercise of powers vested in me. There is a presumption that my actions carry with regard to the correctness of this. This is what Manor goes on. That an authority vested with power, in the exercise of such power,
In absence of any challenge, the presumption applies. That's what you are saying.
Yes.
I understand.
and there is no challenge.
No challenge. He also admits. There is no challenge to this 24th November, 24th September 2023. That he admits.
That is it.
So long it is not on the board, you have not challenged.
Why?
So long it is not on the board, you have not challenged.
So facts are clearly admitted.
Now, facts are admitted. Let's see. Not an issue. Very well. Come to the next bit. On the prayer of maintainability, the court requests of this writ petition, maintainability of this writ petition, this court requests to peruse the reliefs claimed in the previous writ petitions and the orders passed thereunder including the order of the Honorable Division. The parties shall produce the copies of the relevant records on the next day. Poster. The key heading আছে by consent of the parties, the petition shall appear under the heading for orders on. Agree for order. Agree for. March 26, February 26, 2020. Yes. Thank you. এটা দেখে দিন, এটা আজকে ফাইল করবেন।
The last position was
Yes, yes, come. What is this, sir? Affidavit of service filed today, it is taken on record. Yes, what is the matter?
absolutely. Librarian, he died in heartless character. 1995, his father had been
So who died in harness? Mother died. Petitioner received an appointment.
appointment dated 2014, I have the appointment died on 1995. Initially,
So appointment got in 2014. When the application made,
1990.
within 2 years.
No, within 7 years.
Right.
Father died on 14 June.
Now give me the dates. 1 second, sir. Mother,
I don't think April 1995.
10th April 95. Mother died.
27th April 1995, should apply for
1 second. Mr. Prashad, are you seeing that judgment? Compassionate? All cases are covered. Mother died. Then
27th April 1995, he applied.
who applied, sir?
First one.
Application. Then appointment.
2nd August 1996, his application has been rejected by the office.
Then
8 February 2002, communication the rejection order.
very well.
May 2002, did application filed.
First writ petition.
First thing. 10 May 2012, improved order, specified plus with rejection order,
10th.
10 May 2012.
My. Right.
8 July.
One second. Any appeal carried out? No appeal. Then
8 July 2013, order passed
for
for appointment.
appointment made.
Now, 14 August 2014, appointment made.
Direction for appointment.
Direction for
8 July direction for appointment.
14 August 2014 appointment.
Appointment granted.
31st July 2016, he retired.
31st
July,
2016.
he retired.
Petitioner retired. Yes.
He made this application only on the point of his service to be effected from the date of application. That is 27 April 1995.
He wants notional. He wants a notional benefit from 27th April 1995. So the revision of pay, because he has already retired, he has received whatever he.
No, and he has been received previously. Regarding the retirement.
Why?
No payment has been made.
During the period of for the period of 2 years, let's say 14th August 2014 till 31st July 2016. He has to receive.
That happened.
So that he has really worked.
What?
He has actually worked for
What?
that. So that has been received. All right. This is your claim. Yes. Mr. Prashant. Now, what's your full name, sir?
My name is Aposh Kumar.
Taposh Kumar De. Yes, Mr. Prashant.
The earlier round of litigation that the petitioner had faced on this honorable. In that earlier round of litigation, honorable court had set aside the previous litigation and had directed the commissioner to take a decision as such. A legal decision to be passed. Now, the earlier rejection was on the ground that this person
Is it an affidavit? I'm hearing.
no. Now, the earlier rejection that was given on the ground that the petitioner mother was a work education teacher, and her at that point of time, those persons who are working as a work education teacher, the provision is that when he died, the post would be abolished. Therefore, for compassionate appointment, this type of person, their claim would not be.
Show me the order of the single bench and show me the grant of compassionate.
I one by one.
Order of single bench, page 24.
Yes. I want to see the very first rejection. That is page 9.
Not required. You show me
The order of the first rejection.
Read petition.
Page 20. Yes.
You show me which portion you want to place from the single bench order.
on page 25. The second one. The sentence start with it appears. It appears from the impugn order that according to the respondent number 3, the concerned post of work education assistant was abolished on the date of the mother of the petitioner on the basis of government order. No reference of the concerned government order is available in the use. None appears on behalf of the state respondent to assist the court in spite of service of copy of this writ application upon them, as also in the office of the learned government leader Hakurat. In the absence of the reference of the appropriate government order, the court cannot come to a conclusion that the finding of the respondent number 3 is sustainable in law. Besides the departmental order number 874,
Dated such and such.
dated such and such is annexed to this writ application for appropriate adjudication of this case in the light of the above departmental order, the same is quoted here. It has been quoted, Manu. I will
Then,
now, yes.
after considering. Page
After-
27.
After considering the provision of clause 3 of the particular government of the associate
Let's read clause 3.
clause 3 follows the matriculate work education assistants who have been enjoying the scale of pay of rupees such and such may be redesignated as work education
No.
teacher.
Here the mother was not converted. Mother was not redesignated.
Yes, mother was redesignated, and the difficulty that was there, Malu, that post after his death, the post would be abolished. And because of that, Malu, the claim of compassionate appointment will not arise from. That is the
If the post is abolished, what compassionate?
now, Malu, that is the reason that for which Malu the commissioner initially rejected. Now, Malu, but the honorable, this honorable court, Malu, particularly considering clause 3, had directed the commissioner to take a fresh decision because the honorable court had come to a conclusion that it can be considered.
Then show me the order of consideration.
Malu, I am also heavily relying upon this reason because he has accepted this reason. May I show the reasoning of the commissioner or the read of the editor?
In your way. I don't know.
Yes,
No, not required to place enter.
yes. Then Manu kindly come to page 31. Page 31, the last one. In the previous paragraph, the submissions were there.
Yes, you place. Well,
Manu, the third paragraph, the last paragraph. Owing to such scenario of the case, now the matter is examined from the same further under the ambit of the above order of the honorable court.
which page?
Manu, page 31, the last paragraph.
Okay. Going to such scenario.
Yes.
Yes.
Maruta, then late Anandamoy Senapati was absorbed in the post of work education assistant.
Anandamoy was the mother.
Was absorbed in the post of work education assistant created as per June Satansa with effect from 1st of December 1980. The provision which was created in the aforesaid GO is that the government has been pleased to sanction creation of 341 post of work education assistant in the scale of rupees such and such plus usual allowances as admissible in the existing recognized junior school, high school, junior madrasa, high madrasa for absorption of 341 approved non-matriculate part-time craft teacher as personal to the incumbent with effect from 1st of January 1980 until further order. subject to the condition that the post will be abolished as and when the absorbed incumbent vacate the post due to retirement, death, resignation, or other. Therefore, the provision of clause 3 of the GO, such and such, also existed in the GO number such and such, in terms of which the deceased employee was absorbed in the post of work education assistant in her school after creating her post with the same condition. On the other hand, the GO such and such was issued subsequently after the issuance of GO such and such. The provision of clause 2 of the GO dated September 1988 prescribed that as regard death in harmless cases, the same facilities may be allowed to them as are admissible in the case of other employee of the non-government secondary school. This provision cannot be equated with the provision of abolishment of the post, irrespective of either work education teacher or the work education assistant, as the case may be. It has been observed that the mother of the petitioner died on 10th of April 1995, while she was in service since her date of birth, as recorded in the service book, is 3rd of March 1936. She even died prior to issue of the school education department order number such and such and such and such. Thereafter, it has already been decided by various order of the court that the right to be considered for appointment and compassionate ground mature on the date of the concerned employee. Consequently, considering the law of natural justice and rules and or regulation and or government order which are prevalent as on the date of the petitioner mother in the year 1995, I am of the opinion that the petitioner deserves relief in terms of the school education department order number 898 AC primary dated 22nd August 2005, which was in existence then for an interim period, keeping in mind the GO number 457 education B dated 12th of October 1987, read with GO such and such and GO such and such. Provided the other words of the deceased give no objection certificate in this respect, that they have no objection if the petitioner gives such employment under the compassionate ground. This is because neither the petitioner was able to produce a certificate at the time of hearing, nor the district inspector of school, A.C. Howrah, had submitted those together with his memo number such and such, while referred the case to the director. Therefore, the petitioner is directed to submit such no objection certificate in the form of indemnity bond affidavit to the district inspector of school, A.C. Howrah, on immediate basis after receiving this order. Then, the important question: if the district inspector of school, Howrah, received the same certificate from the petitioner, he is directed to examine the same, and after full satisfaction, will enlist the name of the petitioner in the live register maintained in his office for giving appointment to live in a post of group D on compassionate ground, following the steps in terms of apposite order number 890 AC primary dated 22nd August 2005. That was even communicated from this end under memo number such and such to all the district inspector of schools. Thus, the matter is disposed. Then, what the commissioner had done? The commissioner had given the guide that these are the circulars we have to follow, and had remanded back the matter to the TI to consider the case, to examine his entitlement and to
Not entitlement, those certificates are not.
Very
Very well. Then show me that he has received the employment.
Yes. Thereafter, Maluta, here just one sentence I am adding. Maluta examined the case, and after full satisfaction, the portion that was directed to the he is directed to examine the same, and after full satisfaction, will enlist the name of the petitioner in live register. Live register. His name is to be enlisted in the live register. Thereafter, the next order, 2014, the TI had given the approving the service of the petition.
Where?
That is 14th April. That is page 34. This is the one of the 14 April, 14th August 2014. The approval made. ADI had
8th July. It is 10th November 2014. Page 34.
10th November 24. That is the mail. Okay. Some reference were given also. Thereafter, his name was appearing, scale of pay, and the date of appointment.
And the date of appointment,
Yes.
14th August.
Others.
Temporary.
Temporary. After 2 years, he the individual courses after 2 years certificate service he would have.
But he could not pass 2 years. Before that,
2016, as per
he retired.
he retired. Now I am here. Is relying upon relying upon this commissioner order. Yes, ma'am. Why I am relying upon? In the live register petitioner position will be those persons who are before them, he cannot overtake. His live register position would be
When the time comes.
when the time comes. Now 1995 to 2014, those persons who are there in the live register in between this period, the petitioner cannot overtake. And as
Yes.
and another thing, the commissioner had directed the DI to consider the case in the light of those circulars. And those circulars, is specific on this point that if he is found to be eligible, he should be placed in the subsequent position, as per his consent.
Naturally, he cannot overlap.
Now, he has accepted this order with open hand. He had joined. And and another issue that this compassionate appointment is not a
Matter of
matter
right.
of right. Because even I am in the live register, but
It's a discretion of the state, depending upon the policy.
another and the vacancy position.
Of course.
If the
That
vacancy
includes
is not there, he has to remain.
That includes the policy scheme. That includes the scheme.
Yes. Now,
Yes. Yes. So, what according to you, what should be the maximum benefit that could be stretched?
He has accepted, he had acted upon, and he accordingly did that. Therefore, he's prepared for notional notional benefit from his from when the mother was died. It is perhaps it cannot be done because he has accepted, he had acted upon all this. So to that effect, I am placing two judgment. One is Honorable Supreme Court and on track. This is Gokum Dalam case. It was the division bench teacher. With regard to out of turn appointment.
Not possible.
Not possible, that was held in this.
Not possible.
Not
For that, you don't have to rely upon a judgment. The queue has to be maintained. Of course.
Now I would another judgment that I will rely on that is Honorable Supreme Court. That a person cannot approve it at the same time.
This is not the case of approbation or reprobation.
And there the issue is stopped by election. That was also considered by the honorables. These are the two orders I am denying upon.
No, this is the one.
And another one of honorables. I am placing the relevant matter.
Here first you place this.
Okay, it is for out of town.
Yes.
No one. Manuta, the very first two pages that was
Show me the relevant
relevant
paragraph.
portion. Manuta, I am showing you. Manuta, paragraph 10. Manuta, by consent of the parties, the appeal is treated as on day's list and taken up for consideration along with the application for state. The present appeal has been preferred by the state of West Bengal and others against the judgment and order dated 16th of June 2016 passed by the learned single judge in such and such. By the same judgment and order, the learned single judge allow the revision with the following direction. I allow this application by directing the respondent to grant an out-of-term suitable appointment to the petitioner in terms of above recommendation by 31st March 2017. All the papers are before this court. Witnesses were not invited. The allegation contained in the petition are deemed not to have been admitted. The writ application is thus disposed. The question which arises for consideration in the facts of the instant case. Now, in the instant case is whether a mandatory direction upon the concerned respondent could be issued by the learned single judge to suitability upon the petitioner in terms of the recommendation by 31st March 2017 out of that. Upon perusal of the records, it is noted that the respondent petitioner Gautam Dalal had originally approached the court sometime in the year 2012 by filing a petition being WP such, which was disposed of by an order dated 20th of December 2012. The said order contained a direction upon the concerned respondent authority to take immediate steps in accordance with the latest policy of the state government and to ensure that the proposal for appointment of the petitioner was given effect at an early date in terms of the state policy. Subsequently, the respondent petitioner once again approached the court, this time by filing a petition being such and such. That petition was disposed of on 3rd September 2014 with the following observation. I direct the competent authority to issue letter of appointment to the petitioner when his turn will come. I make it clear that the petitioner shall not be superseded by any person whose name appears after the name.
Well, here we are placing from Supreme Court.
No, Manu, that is the Hon'ble division bench. No.
No.
I mean,
Yes. Which portion?
Manu, that is almost paragraph 10.
That's right, but which portion is this? Cannot be superseded.
Manu, that is contained in paragraph 30.
Yes, where you said that superstition, not probably.
Manu, I am reading from 30 to 8. The very first paragraph, that is page 4. Manu, I am reading from page 4 again.
Page 4.
Yes, page 4 of the journal.
Yes. Page 4.
Yes, Manu, I am reading from
Consequently,
subsequently. That is the from
paragraph 13.
paragraph 30.
Subsequently, yes. Subsequently, the respondent.
The respondent petitioner once again approached the court. This time by filing a petition being successful. That petition was disposed of on 3rd of September 2014 with the following observation. I direct the competent authority to issue letter of appointment to the petitioner when his term will come. I make it clear that the petitioner shall not be superseded by any person whose name appears after the name of the petitioner in the concerned register.
That's all.
It is further made clear that in the event the petitioner has already been superseded, the respondent authority is directed to issue letter of appointment in respect of the next available vacancy. The petition is not disposed. In another paragraph 40, consequently, the concerned joint secretary to the government of West Bengal issue an order dated 23rd April 2015, relevant portion to that of his quoted. Hence, I ordered that an appointment in Group C post in suitable vacancy in any GP in Purbo Medinipur district will be considered in favor of Sri Gautam Dala, subject to approval of the competent authority in PNRD department and urgency to fill up the vacancy in exempted category as and when his term comes. The matter is disposed of accordingly. The following order of the
So what is the challenge here?
here, my lord, one of the coordinate bench, my lord, after 2 rounds of litigation had directed that whatever order was passed previously, just forget, you have to give him appointment out of time.
Out of town is not permitted.
Permitted. That
Not
was
permitted. Out of town, not permitted.
not permitted. That was challenged by the government of West Bengal, and accordingly that was upheld by the honorable division bench that it cannot be permitted.
Correct. So
And-
that is neither here nor there.
Yes, because here, as the Malot, he has to, if he is accepting that order, then he has to also accept the serial.
Naturally.
Then Malot, if that be so, then Malot, his employment benefit will arise from the date of his appointment.
Not only that, though he has no right to receive an appointment, compassionate, but the previous rejection was rejected by the single bench on 10th May 2012. 12. Right?
Yes, Malot, that was the, yes, that was the.
And then the direction was given for appointment, consideration and appointment.
Only Malot to pass a reason order.
That's right.
Yes,
And that reasoned order came with an appointment.
and reason order came directing the DI.
Appointment.
Yes,
So previous rejection was rejected on 10th May 2012. First rejection. That was dismissed, set aside
yes.
by 10th May, on 10th May 2012. So,
1996.
no, that was set aside.
That is it.
So, till 10th May 2012, the rejection order was there until it was set aside. So, until it was set aside, it was there.
Yes.
Right. Right.
After set aside, that has been.
Gone. The moment it is gone, you are claiming a retrospective appointment.
Yes.
Whether that is permissible for a compassionate appointment, which is thoroughly a discretionary policy. No. Purpose of the survival, yes. Had it been a case in one of the judgments I delivered, there 2002 approval was made and it was upheld with some modification by the division bench. In 2002, the state authority said yes, give him the appointment, give her the appointment. Matter went back to the school, naturally, for giving the appointment letter and all. The school authority simply did not take any step till 2022. Simply did not take any step. Then when the writ petition came before me, the State Council fairly said on a report, the DI filed a report, then what do? We have done our job in 2002. That he was entitled to get an appointment. No. Then what I did, I granted him all the actual benefits, but the appellate court modified to that extent that no, notional, yes, I get notional, yes. But see, after all, he has not worked, so it's a discussion of the court. Then the discussion. But here is not that case.
1996 rejection.
Rejection.
That has been communicated in 2002 after 8 years.
Yes.
And 2002 application has been filed.
Yes.
That application is disposed of in 2012.
Sir, this is a discretionary policy of the state. It's a discussion point.
What is the state?
You argue. I will hear you. Give me some material in support of your case. Yes, and proceed in your way. No issue. Satisfy me on this point. Proceed in your way.
This point means,
That the rejection was there in 96.
right,
Correct?
communicated 2000.
Ultimately, rejection was set aside in 2012, 10th May. 10th May 2012. So till then, rejection was there. Till then, rejection was there. Right?
That rejection order different by the set aside means the rejection, the order passed by the authority is illegal.
Correct.
On that ground, order that has been rejected.
Correct.
And a illegal order.
Then it was directed to be considered afresh.
Yes.
Which means the court didn't say you give appointment tomorrow. Had that been a case,
It could have some power to give an appointment.
of course, if it finds that the rejection is illegal, totally,
Yes.
can it not direct, sir, that you give totally illegal?
That has,
Appoint him tomorrow.
that has been directed by the.
Let's see the order. Let's see the order. Let's see the order. Single bench.
In view of the.
One second, sir. Let me come. After considering the provisions, 27.
Page 27.
Yes.
After
Oh,
considering.
forget it. In view.
In view of the observation and discuss made at the hearing above, the impugn order suffers from impropriety and the same cannot be sustained in law. The impugn order was and inside. I directed the respondent number 2 to consider the claim of the petitioner by passing a written order. In the
Yes.
light of the observation made hearing in a period of 2 months.
So there is no direction that you give appointment. Again, a discussion was left open to the authority
And
to consider.
and state added the state power and.
To consider.
Yes.
Which means consideration might come in positive, or consideration might come negative. Here in this case, consideration came positive, right? But that will not make you entitled to get a retrospective effect. No. It is a state's benevolent policy. No one can take advantage of it.
Tell me not, but see, yes, I need to live in this world.
No, sir.
And on that ground,
Compassionate appointment is not right. Umesh Nagpal, it's not right.
but that has been given by the state.
84.
That
No
has
right.
been given by the state. So I'm entitled to illusion and benefit.
No.
Otherwise, I do not survive in this world.
At best, a notional from the date of the order of the court, 10th May 2012. Not beyond that. Then yes, 10/5/2012, the previous order was set aside. Consideration was directed to be made. In fact, that may be also far-fetched.
Areas not be a covered just I have to be that in place.
No, I cannot.
But on the date of filing of the writ application, that may be one and
No.
date of only 4 years.
No.
I may protect my client, otherwise,
Protection is not at the behest of the state as well.
state has given
Protection, yes, but show.
and
So there is no mala fide exercise of discretion. There is no mala fide exercise of discretion. There is no mala fide exercise of discretion, sir.
That is the state has given acknowledged after considering the discretion power.
Correct.
On that ground,
At the moment, no, sir. The moment 10th May 2012 order was passed, the rejection stood set aside.
yes.
Fair enough. Then again, the court thought it fit to leave it at the wisdom of the state authority to consider the case
duty that, who will be responsible? Since
Question,
1996,
you know, right? No. No, sir, I'm so sorry, but no.
I will not say.
Ask. Thank you. The writ petitioner had received a compassionate appointment with effect from August 14, 2014, in place and state of his deceased mother, who was a state. Annexure P6 at page 34 to the The mother of the writ petitioner died in Herness on April 10, 1995. Its certificate annexed, sir?
No. Yes,
Very, very. No, it's annexed. No, sorry, no. You will know?
The mother of the international diamond had different day.
The application for compassionate appointment was made on April 27, 1995. Stop. Sir, show me that rejection, 2nd August 96.
Page 91.
The state authority rejected the claim of the petitioner for compassionate appointment on August 2, 1996. Annexure P3. August 2, now August 2 to 9. I'm so sorry. Annexure P3 at page 19 to the reputation. The rejection was communicated to the petitioner on February 8, 2002. Assailing the said decision for rejection of compassionate appointment, of rejection of compassionate appointment, the petitioner filed the first round of writ litigation, being WP number 6696 within bracket W of 2002. The petition was allowed by a courtless bench on May 10, 2012. Annexure P4 at page 20 to the writ petition, whereby and whereunder. Now, whereby the said order of rejection, decision for rejection of compassionate appointment dated February 8, 2002 was set aside.
February 8, 1996.
So sorry. February 8, August 2, 1996. August 2, 1996 was set aside. And the director of school education was directed to consider the claim of the petitioner by passing a recent order. Consider কথাটা vote করুন. In the light of the observation made therein within a specified time frame, and the writ petition was dismissed accordingly. The appeal was carried out from the said order of the court bench. Pursuant to and in terms of the direction made by the coordinate bench dated May 10, 2012, the director the Commissioner of School Education passed its reasoned order dated July 8, 2013, Annexure P5 at page 29 to the writ petition. The petitioner was granted compassionate appointment. With effect from August 14, 2014. Annexure P6 at page 34 to the writ petition. Paragraph. The petitioner had accepted the said appointment and was carried out with his employer accordingly. The petitioner ultimately retired on July 31, 2016. Through the instant writ petition, the petitioner has claimed that the date of appointment of the petitioner should be treated as August 2, 1996, without any remuneration, instead of August 14, 2014, as claimed in Prayer A to the writ petition. Prayer A কথাটা ভুল। Paragraph. এটা কি হেডিং এ অ্যাপিয়ার হচ্ছে? মোশন। Paragraph. Mr. Taposh Kumar De, Land Counsel for the petitioner, submits that immediately after rejection of his claim for compassionate appointment on August 2, 1996, the decision was never communicated to the petitioner, and the same was communicated to the petitioner on February 8, 2000. The petitioner immediately thereafter, in May 2002, the petitioner immediately thereafter filed the previous writ petition. In or about May 2000. The writ petition was pending till 2012 and ultimately was allowed by the coordinate bench by its order dated May 10, 2012. Following the direction of the coordinate bench, the Commissioner of School Education gave appointment to the petitioner with effect from August 14, 2000. The petitioner had no role to play for this long-standing pendency of the writ petition, and therefore, full stop, petition, full stop. The moment the rejection order dated August 2, 1996 was set aside by the coordinate bench by its order under its order dated May 10, 2012. The claim of the petitioner naturally relates back as on the date of rejection, that is August 2, 1996. The petitioner therefore claims the employment benefit with effect from August 2, 1996. This is your case? Any further? No. Sure. Mr. Abhishek Prashad, Land State Council, appears for respondent number. Appearing for respondent numbers.
So 4, 5, 1 to 4, 5.
1, 2, 4 and 5. Submits that. The mother of the petitioner was a work education assistant and then became a work education teacher at the relevant school. In view of the policy of the state, with the death of the mother of the petitioner, the said post for work education teacher was abolished. With the abolition of the said post, there was no question for granting any compassionate appointment for the post. Inasmuch as he further submits that, inasmuch as for granting compassionate appointment, a roster is essentially to be maintained in law. And no beneficiary for such claim can overlap the position in the roster. The situation when arises for compassionate appointment the appointment must be followed by the roster. See. Thus, he submits a beneficiary for compassionate appointment enrolled in such roster has to wait till his /her turn comes. Inasmuch as granting compassionate appointment is a benevolent policy decision of the state and its discretion. Under its discretion. Unless the discretion is used in an arbitrary or wrongful manner, which is apparent on the face of record, the court shall not intervene with the decision of the state authority. The scheme for compassionate appointment has to be followed in its strict compliance. The State Council then refers to the impugned order, then refers to the order of granting appointment dated August 14, 20. Come on, tell me the date of the order.
July 20.
July 8, 2013. Passed by the Commissioner of School Education.
The State Council refers to the order of granting appointment July 8, 2013, passed by the Commissioner of School Education.
And submits that the authority, while passing the order, had considered all the material facts available before him, and none of those facts were ever disputed by the parties. The decision is otherwise well versed, founded, and reasoned. The petitioner has accepted the said decision and joined his employment after receiving the appointment, compassionate. The petitioner has acted upon the said decision for compassion. What more? The London State Council, in support of his contention that the roster has to be strictly followed for compassionate appointment, has relied upon a judgment of the Honorable Division Bench in the matter of লিখে ফেলুন এই দুটো আপনি এক্ষুনি লিখুন এবং রিপোর্টে দেন আমি যেভাবে লিখি ইটালিক্স ক্যাপিটাল করে করুন in the matter of. And what for this?
That is for one of the proposition that Malota spoken by election and after declared that is at paragraph 41.
Not required. Do you seriously rely on this? This is yes. The general principle of law. Full stop. Any further solution?
Malota Whatever benefit he will get from this compassionate appointment, that will be from the date of his appointment. And
is some paragraph, learned state council further submits the petitioner is eligible to receive all the benefits relating to his employment only from the date of his appointment and not beyond that. Then,
and according to all of this,
all right, first up, he submits that this writ petition is devoid of any merit and should be dismissed. Fine. These are all. In reply, it's all right. After considering the rival contentions of the parties and upon perusal of the materials on record, it appears to this court that the facts recorded above are not disputed. And not disputed. It is admitted that pursuant to the direction for appointment made by the Commissioner of School Education dated July 8, 2013, the petitioner had joined at his employment and ultimately retired on July 31, 2016. So, comma, prior to August 14, 2014, admittedly the petitioner did not work. As he did not receive the appointment. The law is well settled that claim for compassionate appointment is not a matter of right or rule. Compassionate appointment is the benevolent policy of the state. If there is no scheme for compassionate appointment for a particular sector of employment, no compassionate appointment can be granted for that sector. Therefore, if there is a scheme for compassionate appointment, each and every provision thereunder has to be strictly followed. Compassionate appointment is not an alternative mode of generation of employment. It is for the immediate survival of the family of the deceased state employee who died untimely. Untimely, so that the family of the deceased employee can survive with the bare minimum. The policy for compassionate appointment is discretion of the state, but of course, the discretion has to be exercised judiciously, legally, and within the framework of law. Paragraph. In the instant case, till May 10, 2012, in the instant case, on May 10, 2012, until the previous rejection order for appointment of the petitioner dated August 2, 1996 was set aside. The said order of rejection held the field. Only after this was set aside on May 10, 2012, it had lost its force. The order of the coordinate bench dated May 10, 2012 was very clear that even after setting aside of the order of rejection, the issue was left. Issue was sent for consideration before the state authority. By passing a reason. The consideration for the The moment the expression consideration, quote unquote, was used by the coordinate bench, it was incumbent upon the state authorities to apply its mind and then pass a reasoned order on the basis of the materials available. The consideration might be affirmative, maybe negative. Therefore, the coordinate bench again left the issue at the discretion of the state authority. And no right was crystallized in favor of the petitioner under the said order of the coordinate bench dated May 10, 2020. The commissioner of the commissioner of school education then, at his wisdom, by applying its discretion on the basis of the available materials, granted compassionate appointment to the petitioner with effect from August 14, 2014. এটাকে জাজমেন্টের ফর্মে ছিল August 14, 2014. On a careful scrutiny of the decision of the Commissioner of School Education dated July 8, 2013, it appears to this court that it is very well versed, reasoned and founded. The authority had considered each and every materials available before it, including the scheme for relevant appointment, and then made the direction. Inasmuch as compassionate appointment cannot have a retrospective effect. Since it is a result of the benevolent policy of the state and its discretion, the petitioner cannot claim any retrospective benefit with effect from August 2, 1996, when petitioner had not even worked and rendered its service to the state authority. To the employer, state authority program, to the employer. Paragraph. For the foregoing reasons and discussions, it appears to this court that on May 10, 2011, after the previous rejection order dated August 2, 1996 was set aside, in exercise of equitable jurisdiction of this court under Article 226 of the Constitution of India. Now, in exercise of its equitable jurisdiction by this constitutional court, a notional benefit can be given to the petitioner with effect from May 11, 2012. May 11, 2012. ওটা তো অর্ডার হয়েছে, ঠিক আছে, যা বলেছি ঠিক আছে, এখন পরের ডেটটা May 11, 2012 ভোট কোনটা 12 হবে May 10, 2012 বলুন কি বললো
For the foregoing reasons and discussions, it appears to this court that on May 10, 2012, after the previous revision order dated August 2, 1996 was set aside, in exercise of
in exercise
equitable of its equitable jurisdiction by this constitutional court, the national benefit can be given to the petitioner with effect from May 11, 2012.
paragraph. Accordingly, who shall be directed? Tell me. Respondent number. Respondent number 4 is directed to give notional employment benefit to the petitioner with effect from bold May 11, 2012 to which the petitioner shall be entitled to commensurating with his employment and the corresponding pay scale. What else? Mr. Prashad,
Other than
any formality?
any one who such a notional benefit will be given in any area.
Yes, this include this notional benefit shall also include arrear, if any, payable to the petition. According paragraph, the entire exercise shall be carried out and completed, including the payment to the petitioner as directed above, positively within a period of 8 weeks from the date of communication of this order to the respondent number. School party.
Yes, yes. Response number 6.
In the event any assistance is required from the respondent number 7, respondent number 6, comma, the respondent number 4 shall call for the said, and the respondent number 6 shall render all assistance to the respondent number 4 in every possible way, without any delay. Paragraph. With the above observations and directions, this writ petition WPA 30332 of 2015 stands disposed of, comma, without any other as to costs. It will be immediately served. Thank you.